From Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Mr. Lazarus, if Congress passes a statute that applies to whatever parameters you want, can the President enlarge the parameters of the statutory text and apply it to areas outside that the statute contemplated?
No.
Okay, because it's interesting because
let me just qualify that. This is an abstract question. It really depends on how the statute's
I understand.
worded. I mean,
and I'll give you a chance to respond because you cite bureaucrats within the administration to justify some of the President's conduct, but you actually don't cite any quotes from the President himself justifying his conduct. And I think it was interesting with this most recent, quote, legislative fix for grandfather plans. Here's what the President said. Already people who predate the ACA can keep those plans if they haven't changed. That was already in the law. That's what's called a grandfather clause that was included in the law. Today we are going to extend that principle both to people whose plans have changed since the law took effect and to people who bought plans since the law took effect. In other words, Obamacare has a grandfather clause. Anything after the enactment of Obamacare is illegal unless it meets the statutory requirements. So what the President is saying is he's extending a grandfather clause to cover plans beyond what the statute contemplates. So you think that that's appropriate?
I think it is. I think you're making a good point. I think that it is appropriate if it is temporary.
And oh, by the way, let me just say, Congress, we passed in the House a bill that would have grandfathered into plans, and I think that we should do that.
But what I meant to say was, I think it is appropriate as a temporary measure if it is necessary to effectively.
It's directly contrary to the statute. The whole point of Obamacare was that you needed to force people into these exchanges. What about this idea? If a political environment is tough, would that be a reason to delay a law or grant a waiver to a law if you cite the political environment as your justification?
I think that would be.
Congress isn't doing what I want. I may suffer political damage, so I'm going to do it anyways.
No, clearly that would not be appropriate.
Well, because I think in your testimony, and you did make some good points, I'll give you that, you didn't cite the President's stated justification for delaying the employer mandate. He was asked about it at a press conference. He said, you know, in a normal political environment, I would pick up the phone, call the speaker, say, hey, this is a tweak that doesn't go to the essence of the law, and we would delay it for a year. But there's not a normal political environment when it comes to quote-unquote Obamacare is what he said. Now, to me, I think that that's totally outlandish of an explanation. It's even more outlandish because Congress, by the time he made that statement, had already passed a bill to delay the employer mandate precisely for the reason that the President suggests. Let me ask you one more question because, Professor Turley, I really appreciate your written testimony, and you cite a lot of examples of the Founding Fathers. And, Mr. Lazarus, you've made the point that, hey, the Take Care Clause doesn't mean what the rest of these guys say. No understanding founders understood it. But you didn't cite any actual Founding Fathers. So can you cite for me a Federalist paper? Hamilton wrote a number on executive power. Can you cite a Constitutional Convention debate, a ratifying convention debate, early practice in the Republic that would substantiate your assertion that that is consistent with the original understanding?
Yes.
Jefferson?
There's very
Madison?
No, there's very little discussion.
Hamilton?
There's very little discussion, but what there is.
Well, right, so then you're making an assertion that's not justified by the historical fact. And I understand the theory that you're positing, but I think it's tough. You've got to back it up. And I think Professor Turley backed up what he was trying to say. So I'm asking you, who would you point to?
Can I finish?
Well, I want you to answer the question.
The answer to the question is that during the Constitutional Convention, this is what I said in my testimony, and this is what the basis of the interpretation is, and I think it's widely accepted. Originally, what became the Take Care Clause didn't have faithfully and didn't have take care in it. It just said that the President shall carry into execution the laws. As the debate went forward, that got changed, and faithfully and take care were added. And
I understand that.
And what I said is that, and there really isn't, and what I said, what that clearly shows, and I think that what scholars on all sides have accepted, that shows that the president is to faithfully, in good faith.
Let me reclaim my time, because you have made that
And
point.
secondly,
And that wasn't my question. My question is about show me something I can go
Well,
where
that's something.
Hamilton's saying this or not. You're talking
This
about
is even
drafting.
more powerful. It doesn't
And I think
matter.
Mr. Turley's point about the language is more correct. But let me just say one other thing.
This is the actual
about
legislative record, and it is more.
So the text matters there, but it doesn't matter with the APA because you're saying the purpose is different from what the text actually says. But I do think, though, the idea of when you're talking about Mr. Cannon's argument about, oh, nobody in Congress, they didn't intend for this subsidy to do. The idea that we know what Congress intended on a 2,600-page bill that many members did not read, much less understand. There were members here swearing you could keep your plan, you could keep your doctor. And now we have members of Congress running around saying, oh, my gosh, I didn't know you wouldn't be able to keep your plan, your doctor. So the idea you're going to rely on that over the text of the actual statute, to me, I don't think I'm a textualist. I would do that anyways. But with this health care law, I think of any law, surely you cannot point to what Congress intended into these intricate provisions because many of them did not read or understand it.
But it's Mr. Cannon. It's Mr. Cannon who is claiming that it was the intention. It was intentional and purposeful of Congress to construe the law in the cramped way in which he does.
I thank the gentleman from Florida. The chair will now recognize